Can y'all hear me?
Mic check 1, 2. Commissioner and Chairwoman, can you hear us?
I can hear you. Can you hear me?
Check. That is good check.
I can hear you.
Good check
Looks
as
like
well.
Brooke and I have the same glasses on.
Oh, you do. Glass twinsies.
Good morning and welcome to the June 3rd, 2026 meeting of the Texas Commission on Environmental Quality. It is 9:30 a.m. I am joined by my colleagues, Chairwoman Pop and Commissioner Gonzalez, our General Counsel, Mary Smith, and our Interim Public Interest Counsel, David Timberger. For each item that argument or discussion is allowed, we will inform parties and the public of time limits for their discussion. Registration closed at 9:30, but if you'd like to address the commission on a particular item, please either visit our registration table if you are here in person, or if you are on the webinar, email agenda@tceq.texas.gov with your name, affiliation, and the item that you would like to comment on. We will do our best to accommodate the request. For those making presentations, please wait to begin your presentation until I've asked you to begin speaking, and please check to make sure that your line is unmuted before proceeding. Ms. Smith, please call the first item.
Item number 1 is the consideration of the Administrative Law Judge's proposal for decision and order regarding the application of LB's Future LLC for renewal of air quality permit number 71793. The parties have been notified that the applicant, the ED, and OPIC will each have 5 minutes of oral argument time. The applicant may speak first and reserve a portion of its time for rebuttal, as the applicant in this show cause hearing bears the burden of proof. With that, we'll begin with the applicant. The applicant has not registered, so I'll see if there's anyone representing the applicant in the audience.
You want to move on to the ED and come back?
Yeah, let's do that.
Good morning, Commissioners. General Counsel, Public Interest Counsel. My name is Caitlin Ding with the Environmental Law Division, representing the Executive Director. For the reasons discussed in the Executive Director's motion for summary disposition and the Executive Director's response and exception to the Administrative Law Judge's proposal for decision, as filed, the Commission should void the current permit renewal application and the current permit issued to LB's Future LLC for air quality permit number 71793. Expire immediately. LB's Future LLC, also known as the applicant, applied to the Texas Commission on Environmental Quality for the renewal of air quality permit 71793, which would authorize the continued operation of a pet crematory in Harris County, Texas. The applicant filed the application on December 14th, 2024. TCEQ staff reviewed the application and found deficiencies that were communicated to the applicant in a notice of deficiency letter dated April 24th, 2025. The Administrative Law Judge granted the Executive Director's motion for summary disposition due to there being no genuine issue as to any material fact, because no party presented any evidence to rebut evidence provided by the Executive Director that shows that the applicant is not a legal entity or person eligible to submit an application for an air quality permit. Further, the evidence showed that the applicant failed to submit proof of publication notice of the NORI, including notarized affidavits from the newspaper and tear sheets by the 30-day deadline of January 20th, 2025, and again by the May 1st, 2025 deadline and the notice of deficiency. The Administrative Law Judge recommends that the application be denied. The Executive Director recommends adopting the Administrative Law Judge's recommendation and the proposal for decision, with the following corrections to the PFD. First, to correct an error in the proposed order located in the first paragraph, and second, to correct an error in the conclusion of law number 15. The Administrative Law Judge erroneously indicated that the summary disposition was granted in favor of the applicant instead of the Executive Director in both instances. The Executive Director maintains her position that the permit renewal does not meet all applicable statutory and regulatory requirements, and therefore the applicant's current permit and permit renewal should be voided. The Executive Director respectfully recommends that the Commission adopt the Executive Director's suggested corrections to the Administrative Law Judge's proposal for decision. Thank you, and I'm available for any questions.
Any questions from my fellow commissioners?
No.
OPIC?
Good morning, Chairwoman, Commissioner Gonzalez, Commissioner Miller, General Counsel Smith, and Executive Directors, Attorney, and staff. My name is Eli Martinez. I am Senior Attorney with the Office of Public Interest Counsel for the record. OPIC supports the Administrative Law Judge's proposal for decision on summary disposition and recommends that the Commission adopt the PFD, dismiss the renewal application with prejudice, and order the immediate expiration of air quality permit number 71793. Two independent and undisputed grounds support summary disposition. The first is lack of legal capacity. the Secretary of State forfeited LB Future LLC's charter on February 23, 2024, pursuant to Texas Tax Code, Section 171.309. Under Health and Safety Code 382.003, sub 10, only a person defined to include a valid legal entity may apply for an air permit. A forfeited LLC is not a legal entity eligible to hold or renew a permit. This is a pure question of law with no genuine issue of material fact. Secondly, there was the failure to provide required public notice. Despite the 30-day statutory deadline, a notice of deficiency, multiple contacts by staff, and a specific NOD deadline of May 1st, 2025, the applicant never submitted proper proof of publication of the NORI, including notarized affidavits and the newspaper tear sheets. These procedural requirements are mandatory under Health and Safety Code 382.056 and Chapter 39 of our rules. Additionally, the applicant failed to respond to discovery, file a direct case, or file a response to the motion for summary disposition. The executive director's evidence, therefore, stands unrebutted. There is no genuine issue as to any material fact, and the executive director is entitled to judgment as a matter of law. Thank you for your time. I'm available for any questions.
Thank you. Any questions?
Nope.
Has the applicant signed in, Mary?
No, the applicant hasn't signed in, and they don't appear to be online either.
Okay. Item 1 concerns the application of LB's Furniture LLC for the renewal of air quality permit number 71793, which would authorize the continued operation of a pet crematorium in Harris County. After reviewing the record, I agree with the ALJ that there is no genuine issue as to any material fact in the case because no party presented evidence to rebut the ED showing that the applicant is not a legal entity eligible to apply for the air quality permit, and the applicant failed to submit proof of publication of the notice of receipt of application and intent to obtain a permit by the established deadlines. As a result, I agree with the ALJ that the renewal application should be dismissed and air quality permit number 71793 should expire immediately. While I recommend that we adopt the ALJ's proposed order, including the changes noted in his April 30th, 2026 exceptions letter, I would like to propose 5 additional changes to the proposed order. First, in the order's first paragraph, add the renewal of before air quality permit number 71793. To clarify that this matter involves a renewal application. Next, to ensure that details regarding preliminary hearing notices are included in the Commission's order, I would add finding of fact 13A to state notice of the preliminary hearing was published in English in the Houston Chronicle on October 12, 2025, and in Spanish in La Prensa de Houston on October 12 through 18, 2025. The notice included the time, date, and place of the hearing, as well as the matters asserted in accordance with the applicable statute and rules. Third, for consistency with the remainder of the order, in conclusion of Law 17, I would replace denied with dismissed. Fourth, to clarify that the dismissal is without prejudice to filing a new application. Although at this point there would be no ability to file a renewal, I would add without prejudice after dismissed in ordering paragraph number 1. Finally, to ensure that the chief clerk is instructed to serve the order, add ordering provision 3A to state TCEQ's chief clerk shall forward a copy of this order to all parties. Chairwoman Pop, Commissioner Gonzalez, thoughts?
No, I agree with the ALJ and I agree with your changes. I'm also in agreement.
Since we're all in agreement, I move that we adopt the administrative law judge's proposed order as revised by the ALJ's letter regarding exceptions dated April 30th, 2026, and with the following changes. In the order's first paragraph, add the renewal of before air quality permit number 71793 to clarify that this matter involves a renewal application. To ensure that details regarding preliminary hearing notices are included in the Commission's order, add finding of fact 13A to state notice of the preliminary hearing was published in English in the Houston Chronicle on October 12, 2025, and in Spanish in La Prensa de Houston on October 12 through 18, 2025. The notice included the time, date, and place of the hearing, as well as the matters asserted in accordance with the applicable statute and rules. For consistency with the remainder of the order, in conclusion of Law 17, replace denied with dismissed. To clarify that the dismissal is without prejudice to refiling an application. To order provision 1, add without prejudice. and to ensure that the chief clerk is instructed to serve the order, add ordering provision 3A to state TCEQ's chief clerk shall forward a copy of this order to all parties. Dismiss the application by LB's Furniture LLC to renew air quality permit number 71793 without prejudice, and order that air quality permit number 71793 expires on the date the order is signed.
And just to clarify, the company's name is LB's Future.
Future, LB's Future. Did I say furniture? Okay. Are we all in favor? Say aye.
Aye. Aye.
The motion, I need
Get
a second. Do I have a second before we vote?
I second.
Thank you, Chairwoman. All in favor?
Aye.
Aye. The motion passes now, Ms. Smith. Call the next item.
We'll give folks a moment to switch desks, seats. Item number 2 is the consideration of the application by Flying Bar D Ranch LTD for new Tipneys permit number WQ00164850001. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
Thank you. This item involves an application for a domestic wastewater discharge permit of 35,000 gallons per day in the final phase of Guadalupe County. We received hearing requests from Citizens United for Lake Placid, Craig and Nancy Russell, and Terry and Belma Smith. For wastewater discharge permits, we first review whether the hearing requesters have demonstrated that they are entitled to a contested case hearing by showing that they are affected by the application in a manner different than the general public, and by raising issues that are relevant and material to the Commission's consideration of the application. Groups and associations may also be eligible for a contested case hearing if they identify a member who has standing in their own right to request a hearing and that the interests that the group seeks to protect are germane to its purpose. For this application, I would grant the hearing requests of Craig and Nancy Russell, and I would deny the remaining hearing requests. First, I believe that Nancy and Craig Russell, whose property is adjacent to the facility property, demonstrate that they would be affected in a manner different than the general public. Furthermore, they raised relevant and material issues in their timely comments and hearing requests, such as water quality, so I believe they meet the procedural and substantive requirements for a hearing. Regarding Citizens United for Lake Placid, I believe that the group failed to adequately explain how the interests that the group seeks to protect are germane to its purpose. I don't believe they have adequately connected how their concerns for the beauty, use, and enjoyment of Lake Placid and the surrounding area relate to this facility and discharge, especially given the discharge point to the Guadalupe River is significantly downstream from the lake. I would deny the hearing requests of the Smiths. While they live a short distance from the proposed outfall, they only raise issues related to a concern that the additional discharge will result in flooding. Since this is not within the Commission's jurisdiction to consider here, I would deny the request. I'll turn to my colleagues. Chairwoman Pop, thoughts?
There we go. I agree with you on the Russells. They're adjacent to the facility and the state that they will be affected by odors. So I think they demonstrated how they will be affected by the proposed wastewater treatment plant in a manner that is different from the general public. I would also refer Culp. I see their purpose, the beauty, use, and enjoyment of Lake Placid and the surrounding area as germane to the interests that they raise regarding inundation of the facility and the odors. The facility borders Lake Placid, and the wastewater treatment plant will be less than 1/2 mile from the lake. The group also names members who would have had standing in their own right, specifically the Russells. And the group's timely comments and hearing requests raised multiple relevant and material issues that are within our jurisdiction to consider. And I would deny the Smiths because the issues they raised are related to flooding, and that is not within our jurisdiction.
Commissioner Gonzalez?
I agree with you, Commissioner Miller. I don't think that Citizens United for Lake Placid meets our rule requirements for an affected organization because they raise general concerns and the discharge is downstream of Lake Placid. And I also don't believe that they sufficiently demonstrated that the interests the group seeks to protect are germane to its purpose as required by 30 Texas Administrative Code, Section 55.205B3. But otherwise in agreement with you.
Okay, thank you. So turning to the issues, the Russells raise relevant and material concerns regarding water quality and protection of aquatic life and livestock. I would refer a single issue covering these concerns to SOA, refer the parties to ADR, and set a hearing duration of 180 days. I would also deny all requests for reconsideration. In my view, the issues raised in these requests are adequately addressed in the ED's RTC, or response to comments, or will be addressed through the contested case hearing process. Colleagues?
I'm in agreement with that.
I'm in agreement with that, and I think so will take care of parties. So let's go forth.
Do I have a motion?
I move that we grant the hearing request of Craig and Nancy Russell, deny all remaining hearing requests and requests for reconsideration, refer the application to SOA for a contested case hearing on the following issue: whether the draft permit is adequately protective of water quality, human health, aquatic life, livestock, and wildlife in accordance with applicable regulations, including the Texas Surface Water Quality Standards and applicable anti-degradation standards. Refer the matter to the Commission's Alternative Dispute Resolution Program to run concurrently with the SOA preliminary hearing scheduling efforts, and set a hearing duration of 180 days from the date of the preliminary hearing until the proposal for a decision is issued.
Do I have a second?
I second.
All those in favor?
Aye.
Aye.
Aye. The motion passes. Ms. Smith, call the next item.
Item number 3 is the consideration of the application by Motiva Enterprises LLC for air quality permit number 175017, PSD TX 1632, and GHG PSD TX 236. The parties have been notified that the commissioners will not take oral argument but may ask questions. Those who have signed in would be noted for the record.
Thank you. Motiva Enterprises has applied for a new source review authorization for the construction of a new cogeneration unit using 2 combined cycle gas turbines to provide electricity and steam in Jefferson County. One hearing request was received from Port Arthur Community Action Network. PACAN identified one member it believes has standing to request a hearing in its own right, John Beard Jr., and raises concerns regarding air quality impacts and resides approximately 1.49 miles from the facility's nearest emission point. In my review of the hearing request and draft permit, including the issues raised by Mr. Beard and the information about the location of his residence with respect to the nearest emission point, I find that he does not qualify as an affected person in this matter, and therefore PECAN cannot have associational standing to be eligible for a contested case hearing. So I would deny the hearing request, adopt the ED's response to comments, and issue the permit as recommended by the Executive Director. Chairwoman Pop, thoughts?
I agree.
Commissioner Gonzalez?
I
agree.
With agreement, do I have a motion?
Yes, I move that we deny all hearing requests, adopt the Executive Director's response to comment, and issue the permit to Motiva Enterprises LLC as recommended by the Executive Director.
Do I have a second?
Second.
All those in favor?
Aye.
Aye.
Aye. The motion passes. Ms. Smith, please call the next item.
Item number 4 is the consideration of the petition for the creation of the Preserved Municipal Utility District of Collin County. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
Item 4 involves a district creation petition and request for additional road powers with one hearing request filed by Senator Bob Hall. For district creation matters, the commission must determine the effectiveness of hearing requesters under the rules in 30 TAC Chapter 55, Subchapter G. I agree with the analysis of the ED and OPIC and the petitioner that all recommend denial of the hearing request because Senator Hall failed to identify any personal justiciable interests. I agree with the ED's technical analysis of the petition and recommend that we create the district, grant the request for additional road powers, and appoint the 5 requested temporary directors. I am comfortable with the ED's proposed order to accomplish these decisions, but I think we should indicate that the initial directors appointed by the order are temporary directors under Texas Water Code, Section 54.022. Chairwoman Pop, thoughts?
I agree.
Commissioner Gonzalez?
Also in agreement.
Wonderful. Do I have a motion?
I move that we deny all hearing requests, grant the petition for the creation of the Preserved Municipal Utility District of Collin County, and grant it additional road powers, and issue the executive director's proposed order for creating the district, granting it additional road powers, and appointing the 5 proposed temporary directors, but indicate that the initial directors are temporary directors under Texas Water Code, Section 54.022.
All those in favor?
Second.
Oh, I need a second.
I second.
Now, all those in favor?
Aye.
Aye. The motion passes. I'm ready to move on without seconds. Just. Ms. Smith, please call the next item.
Okay, item number 5 is the consideration of the petition filed by Patrick Road Investors LP for the creation of Grove Creek Municipal Utility District of Ellis County. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
Thank you. This item before us is a municipal utility district creation matter proposed to be located entirely within Ellis County. Ellis County is the sole hearing requester. For district creation matters, we look only at whether the hearing requester is entitled to a hearing. A protesting party must identify their personal justiciable interests that would be affected by the application, including a statement explaining how and why the requester believes they will be affected by the activity in a manner not common to members of the general public. When considering whether a governmental entity is affected, in addition to the other factors listed in 30 TAC 55.251, the Commission considers the entity's statutory authority over or interest in the issues relevant to the application. After reviewing Ellis County's hearing request in this matter, I find that the county identified its statutory authority over issues relevant to the petition and sufficiently explained how its authority could be impacted by this petition. In my view, in this instance, Ellis County sufficiently demonstrated it is an affected person, and I recommend that we refer this matter to SOA. I would also recommend setting a maximum hearing duration of 180 days and a referral to the Commission's Alternative Dispute Resolution Program to run concurrently with the SOA scheduling process. Chairwoman Pop, thoughts?
Agreement.
Commissioner Gonzalez?
I'm actually not in agreement. After reviewing the record, I would deny Ellis County's request for hearing as recommended by the executive director. Under our rules, we must consider all relevant factors, including statutory authority over or interest in the issues relevant to the application, but this is not where inquiry ends. Merely listing statutory authority without explaining how the regulated activity poses a clear risk amounts to a generalized concern, in my opinion. Here, I do not believe that the county meaningfully articulates how the district creation will affect its interest or sufficiently explains how the county will be impacted by specific developments contemplated by the petition. Given the general concern and lack of specificity, I do not believe the county sufficiently identified a personal justiciable interest affected by the application as required by our rules. In addition, the ED reviewed and considered the comments raised during the application review process, and I believe that the county had an adequate opportunity to provide its opinions on the petition as it is done here. Thus, I would deny the county's request. I reviewed the ED's technical memo and other documents supporting the petition, and I believe that the information shows that the proposed district is feasible, practical, and necessary, and would be a benefit to the land to be included in the district. So,
Okay. So with that, maybe Chairwoman Pop, do I have a motion?
You do. I move that we deny all hearing requests, grant the petition for the creation of the Preserved Municipal Utility District of Collin County, and granted additional road powers, and issue the executive director's proposed order for creating the district, granting it additional road powers, and appointing 5 proposed temporary directors, but indicate that the initial directors are temporary directors under Texas Water Code, sections 54.022.
Oh, did she? Chairwoman Pop, what was the first sentence of your motion?
I move that we deny.
Is that what you meant?
Oh, I'm
Or
sorry.
do you mean to grant Ellis County's hearing
Sorry,
request?
excuse me. Sorry, Katerina. I move that we grant the hearing request of Ellis County, refer the matter to SOA for a contested case hearing on the petition, and refer the matter to the Commission's Alternative Dispute Resolution Program to run concurrently with SOA's scheduling process, and specify that the maximum hearing duration is 180 days from the date of the preliminary hearing until the proposal for decision is issued.
I will second your motion. All those in favor? Aye.
Aye.
All those opposed?
nay.
The motion passes. Ms. Smith, please call the next item.
Item number 6 is the consideration of the application by Western Refining Company, LLC, for renewal and amendment of air quality permit number 18897. The parties have been notified that the commissioners will not take oral argument, but may ask questions, and those who have signed in will be noted for the record.
Thank you. In this item, applicant is asking the commission to adopt a draft permit for its El Paso refinery that contains a renewal application that will also incorporate the refinery's permits by rule and standard permits, as well as a minor amendment application that makes some changes to tank emissions at the refinery. For air applications, the commission first analyzes whether a hearing requester is affected and entitled to a hearing, and if we find that a requester is affected, we determine which relevant and material issues are appropriate for referral to SOA. I'll begin with effectiveness. To be considered an affected person, a requester must explain how they will be affected by an application in a way that is not common to members of the general public. For governmental entities such as counties, the commission also considers whether the government has statutory authority over or interest in issues relevant to the application. Groups and associations may also be eligible for a hearing, but they must show that they have at least one member with standing in their own right to bring a hearing and show that the interests that the group seeks to protect are germane to the organization's purpose. Finally, for any hearing request to be granted, it must be based on timely filed comments and raise relevant and material issues for the commission to consider. With that, I'll begin with effectiveness and who has a right to a hearing. I would grant the hearing request of El Paso County and deny the remaining hearing requests. The county provided 2 bases for effectiveness. First, the county notes its statutory authority to inspect air emissions, which is relevant to the application. Second, the county raises its property interest in nearby Ascart Park and its interest in protecting the property and its concerns regarding how air emissions from the facility will impact the county's use of the park. The county raised these concerns in its timely filed comments and provides several relevant and material issues for the commission's consideration. So I would refer them to SOA for a hearing. I would deny the remaining requests. Echo El Paso did not file timely comments, did not identify a member with standing in their own right to request a hearing, did not explain how the interests that the group seeks to protect are germane to its purpose, and provided no issues for referral. The remaining individual hearing requesters either failed to provide an address, failed to provide issues, failed to file timely comments, raise concerns on behalf of others or not themselves, are located too far from the refinery to reasonably be affected differently than the general public, or some combination of these issues. Therefore, I would deny the remaining hearing requests. Commissioner Pop, Chairwoman Pop, sorry.
No, go ahead. I would grant the hearing request of El Paso County and deny the other hearing requests for reconsideration. El Paso raises both statutory interest that is relevant to the application and owns property that is approximately a half mile from the refinery. The county raised concerns that are relevant and material to our decision on this application, including the air quality concerns at the property, air nuisance concerns for its property, and concerns that air quality analysis and air dispersion modeling was not properly conducted. These were timely raised in its comments in its hearing request. So I grant the county's hearing request and refer the issues I just noted to SOA for a contested case hearing. The other hearing requests, in my view, are subject to either procedural or substantial defects, and I would not grant these requests. And as far as the requests for reconsideration are concerned, I believe that the concerns are either adequately addressed by the ED's RTC or will be addressed in the contested case hearing. So I would deny the RFRs.
We want to do that first. We do that before Commissioner Gonzalez.
So I just received notification that Representative Vincent Perez is here and would like to read a letter to the commissioners. Would you like for Commissioner Gonzalez to make her remarks first, or would you like to have the representative's address?
You want to be quick? Okay.
Yeah. I'm in agreement with both of you that the county has sufficiently demonstrated that it's an affected person pursuant to TCEQ rules because of the statutory authority over inspection of air emissions under the Texas Health and Safety Code, and because of its property interest in Escarte Park, just 0.52 miles from the refinery. Here, the county did more than just list its statutory authority and explained how its interests would be impacted in a manner different than the general public. Thus, I agree with OPIC that the county's hearing request should be granted, and I would also deny the remaining requests because of procedural and substantive defects.
Thank you, Commissioner.
And I guess we have a representative from Representative Perez's office. So as a reminder, we do allow members of the legislature or staff members of the legislature to read letters from elected officials. Of course, the commission's decision must be made on the record and the briefing by parties in the case.
Good morning, everyone. Thank you so much for letting me read this letter on behalf of State Representative Vincent Perez. He has asked that I read this letter into the record, and so I will go ahead and start. It's also been emailed to you all, so I hope you'll be able to access it as well. Dear Chairman and Commissioners, as a representative for Texas House District 77, which includes the El Paso community surrounding the Marathon El Paso refinery, I respectfully submit this public official comment on the above referenced application to urge the Commission to grant a contested case hearing before it acts on permit number 18897. The Marathon El Paso refinery sits at 212 North Park Drive, surrounded by one of the oldest residential neighborhoods in our city, in a county already designated moderate non-attainment for particulate matter under the Federal Clean Air Act. My concern is less about any single number than about the process by which emission increases at the refinery have come to be authorized, and whether that process has given the public the deliberate, transparent review a matter of this consequence deserves. real emission increases are being characterized as no increase. For years, emission increases at this refinery have been authorized through permit by rule and standard permits. These are lawful routine tools, and Marathon has done nothing improper in using them. But by design, they do not carry the public notice, comment, and hearing rights that attach to a full new source review permit. This renewal now folds those by rule and standard permit authorizations into permit number 18897. By the executive director's own account, the application's plain language summary reflects volatile organic compound emissions rising from 570.95 to 587.13 tons per year. What the executive director describes as an apparent increase of 16.18 TPY. The executive director nonetheless concludes those tons are not considered as an increase because they originated in a permit by rule and standard permit consolidations, and notes that the amendment authorizing these changes did not trigger the threshold for public notice, so none was given. Whatever the regulatory label, the community is being asked to absorb additional emissions that never received independent public scrutiny, now presented as routine. Secondary, the Commission's own Office of Public Interest Counsel has concluded a hearing is warranted. This is not only my view. The Commission's own Office of Public Interest Counsel, the office charged with representing the public's interest within this agency, reviewed the same request and recommended that the Commission find El Paso County to be an affected person, grant its hearing request, and refer the matter to the State Office of Administrative Hearings for a contested case hearing of up to 180 days. The office also identified 5 relevant and material issues of fact for that hearing, including whether the air quality analysis and the emissions calculations methodologies in the application are flawed or outdated. When the agency's own counsel reaches that conclusion, it deserves the Commission's serious weight. Two further points from that office's review bear emphasis. First, OPEC declined to treat this as a no increase renewal at all, noting that the plain language summary itself indicates increases in VOC, NOx, and CO emissions. Second, that office reported that the amendment application and its technical review documents were not available for public review when it conducted its evaluation. So the very office tasked with protecting the public's interest was unable to examine the material behind these increases. If the agency's own counsel could not review them, the public certainly could not. A contested case hearing is the forum in which those materials are finally placed on the record and tested. The refinery's compliance history is an independent basis for a hearing. Texas law gives the Commission a second and independent ground to grant this hearing, the applicant's compliance history. Commission rules permit a hearing on a permit renewal where a facility's violations are unresolved and reflect a reoccurring pattern of egregious conduct that demonstrates a consistent disregard for the regulatory process. This refinery's record warrants that scrutiny. Since Marathon assumed operations in 2018, the facility has received 5 notices of violation from the TCEQ, arriving from its own emissions reports, and in 2020 it reported 4,008 pounds of unauthorized emissions. These are not isolated lapses. They reflect repeated failures to operate within the limits that the Commission has set. The trend in this facility's reported toxic release compounds the concern. According to the EPA's toxic release inventory, the refinery released 135,700 pounds of air toxics in 2022, its highest total since 2014. That figure included 6,229 pounds of benzene, a known carcinogen, and the most reported since 2016, 1,283 pounds of hydrogen sulfide, a 10-year high, and 72,902 pounds of ozone precursors. A facility whose toxic emissions are climbing to multi-year highs in a residential neighborhood already in non-attainment is precisely the kind of applicant whose compliance history merits a hearing rather than a routine renewal. In nearly a century of operations, this permit has never faced adversarial review. This refinery has operated on the same Midtown site since 1928. In all of those decades, through every prior permit and renewal, no air permit application for this facility has ever been examined by an administrative law judge in a contested case hearing. The first time the Commission's own Office of Public Interest Counsel recommended one, and the first time it does so on record where the underlying technical documents were not even available for public review, is exactly the moment that unbroken precedent should give away. A century of operation besides homes, schools, and churches has earned this community one adversarial on-the-record proceeding. I want to be clear about the limited nature of what I am requesting. I am not asking the Commission to deny this permit or to close a refinery that employs hundreds of El Pasoans and supplies much of our region's fuel. I am asking to open the structured forum, one of the Commission's own alternative dispute resolution process can help resolve through mediation, in which the county, community, and the company sit at the same table before a neutral judge. The realistic goal is negotiated and foreseeable emissions concessions, not closure. I recognize the Commission retains discretion in these matters, but where the agency's own public interest counsel has identified a qualified affected person and relevant material disputed issues of fact, where real increases have been characterized as no increase, where the underlying documents were not available for public review, and where the facility's compliance history reflects a recurring pattern of unresolved violations, the case for an open and deliberate proceeding is strong. Residents across my district have asked for the same hearing. I respectfully urge the Commission to follow its Office of Public Interest Counsel's recommendation and grant a contested case hearing on permit number 18897, a proceeding focused on the emissions calculation methodologies for VOC, NOx, and CO, the reliability of the permit by rule consolidation accounting, and the adequacy of the air quality modeling for a community already designated non-attainment. Thank you for your consideration. On behalf of Representative Vincent Perez.
Thank you so much for being here today. Appreciate the comments. Colleagues, since it seems we're in agreement on El Paso County being an affected person, I'm going to move on to the issues. In my review of the county's request, they raised concerns relating to the protectiveness of the permit with regard to air quality and human health, air nuisances, and air quality analysis, emission estimates, and air dispersion modeling. These are all relevant and material issues for the draft permit, so I would refer these issues to SOA. If we're in agreement on issues, I believe that an ADR referral is appropriate and would set a 180-day hearing duration. Finally, in my view, the requests for reconsideration are either adequately responded to by the ED or are the subject of the contested case hearing and better addressed through an evidentiary hearing. So I would deny all RFRs. Chairwoman Pop, thoughts?
I agree.
Commissioner Gonzalez?
I'm also in agreement.
Do I have a motion?
I move that we grant the hearing requests of El Paso County, deny the remaining hearing requests and request for reconsideration, refer the matter to SOA for a contested case hearing on the following issues. A, whether authorized emissions under the draft permit will be protective of human health, general welfare, and physical property. B, whether the draft permit will be adequate to protect against nuisance conditions from air contaminants affecting county property in accordance with 30 Texas Administrative Code Section 101.4, and C, whether the permit application contains accurate and complete air quality analysis, emissions estimates, and air dispersion modeling. Specify the maximum duration time for the hearing is 180 days from the preliminary hearing to the issuance of the proposal for decision, and refer the matter to the Commission's ADR to run concurrently with the SOA preliminary hearing scheduling efforts.
Do I have a second?
A second?
All those in favor?
Aye.
Aye.
Aye. The motion passes. Ms. Smith, please call the next item.
Item number 7 is the consideration of the application by LGS Precast LLC for air standard permit number 180792. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
Before us, we have an application for registration under the standard permit for concrete batch plants, which would authorize the construction and authorization of a new concrete batch plant in McLennan County. For these types of applications, the legislature has directed the commission to consider only those individuals actually residing in a permanent residence within 440 yards of the proposed plant as an affected persons. The commission received numerous hearing requests in this matter. After reviewing the requests, I would deny the requests of Dan Pullen and 3500 Myers Lane LLC as they failed to meet the statutory residential distance limitation for effectiveness in this matter. And I would grant the request of Stephanie and Rochelle and the requesters who live at the Village Square apartment complex as I found that these requesters reside within 440 yards of the proposed facility and raise personal justiciable interests. Due to the number of requesters in this matters, I have a handout labeled Attachment A that lists the names of the individuals that I recommend are affected persons. We can distribute that to persons in the room.
And I'm going to distribute that via email to the 2 remote commissioners.
I'll give you guys a chance to look at it, and then when you've had that chance, we can see if we're all in agreement.
I'm in agreement.
Thank you, Commissioner. Chairwoman Pop?
I am too.
Okay, then moving on to the issues, I found that the hearing requests raise relevant and material issues regarding health impacts, air quality, including concerns regarding particulate matter and dust from the proposed facility affecting the requester's use and enjoyment of property. I would recommend that we refer these 3 issues to SOA. I would also recommend that the commission deny all requests for reconsideration. And finally, I would recommend 180 hearing duration. Colleagues, are we in agreement?
Yeah, I'm in agreement.
Okay. I move that we grant the hearing requests of the requesters identified in Attachment A, circulated from the dais today. Deny the remaining hearing requests and requests for reconsideration. Refer the application to SOA for a contested case hearing concerning the following issues: whether the permit contains adequate conditions to protect the health of the requesters and their families, whether the permit demonstrates compliance with air quality standards, particularly with respect to particulate matter, and whether the permit contains adequate conditions to be protected against nuisance dust in accordance with Texas Administrative Code, Section 101.4, including conditions affecting requesters' use and enjoyment of property, and specify the maximum duration of the hearing is 180 days from the preliminary hearing to issuance of the proposal for decision. Do I have a second?
I second.
I heard the chairwoman first. If
Okay.
We'll mark that.
All those in favor? Aye.
Aye.
The motion passes. Mrs. Smith, call the next item.
Okay, that takes us to the enforcement docket, which are items 8 through 58. And the executive director's staff is here to present these matters.
Do we have anyone signed in on these items? Okay.
Let them do their presentation.
I'm skipping ahead again. I am really efficient up here.
Good morning, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Megan Hamilton of the Enforcement Division, and with me today are Amy Sedemeyer, also of the Enforcement Division, and Anna Treadwell of the Litigation Division, representing the Executive Director. Pending before you are items 8 through 58. The total assessed administrative penalties are $2,539,767, with $253,011 deferred, $1,199,111 applied towards supplemental environmental projects, and $1,087,645 to the general revenue. We respectfully request approval of these items and are available to answer any questions you may have.
Thank you so much. Any questions, Commissioners? Chairwoman? No? Okay. No.
So we don't have anyone who's asked to address the commissioners, but we have individuals signed in on 9, 10, 11, 12, 13, 14, 16, 17, 22, 25, 28, 30, 39, and 40 who are all available to answer questions should you have any.
Any questions for any?
No.
Okay. Comments from OPIC?
OPIC has reviewed each of these enforcement items, and we support adoption of all the orders presented by the ED staff.
Thank you. That was short and sweet. As always, I appreciate all the hard work that went into this, getting these 50 enforcement orders before the commission today. I'm prepared to move forward with these items. Colleagues?
Let's do it.
Okay, do I have a motion?
Yeah, I just have a quick comment, though. I do appreciate the staff's hard work to get these orders to this point, and thanks for continuing to improve your internal processes to do that. I also want to point out that there are a number of compliance steps included in today's orders, and I want to encourage respondents to take advantage of our supplemental environmental projects or the SEP program when they can. I think it's a great program, and I appreciate that respondents are working on improvements in their own facilities to come into compliance. So I also have reviewed the orders and prepared to adopt them.
Great comments. Thank you, Commissioner. Do I have a motion?
I move that we adopt items 8 through 58 as recommended today by the Executive Director.
Do I have a second?
I second.
All those in favor? Aye.
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 The motion passes. Thank you. Mary, can you call the next item?
Our next item is the public comment session, and at this time, we don't have anybody registered to provide comments today. We can pause for a moment, see if there's anybody in the room that would like to address the commission. Seeing none, we can move on to items 60 through 63. These items were for closed session, but the commission will not be meeting in closed session today.
And with that, the agenda stands adjourned. The time is 10:23 a.m. Thank you.
Thank you.